Hello, Dr. Marino. This is Dan Kessinger, and today I will be covering our Project 1, which is on the funeral arrangement and business law. And then we'll be talking about the main two topics of wills and contracts. So this is the agenda that I'll be following. We're going to identify the types of wills, the frequent terms of wills, discuss some limitations of a non-competitive will, explain the difference between distributing property per capita and per stirrups, and identify the prime duties of an administrator and how they differ from those of an executor. I'm going to then state the 5 requirements for a valid contract and briefly compare them to the funeral contract. I'll describe some types of contracts and how they differ from agreements during the funeral arrangement conference, and explain the difference between contract and quasi-contract, and then open it up for any questions. But first, we're going to talk about wills. Watch this short video on the importance of wills.
Making a will, it's pretty important, you know. And it's not just for old people either. A will can help protect the ones you love if the worst happens. And can ensure that the things you leave behind end up going to the right people. Click to find out how a solicitor can help you to make a reliable will that's right for your needs. Use a professional. Use a solicitor.
So I hope you enjoyed that little video on the importance of establishing a will. So there are different types of wills, and we're going to cover a few of them here and identify them. First of all, a will is a form that prescribes law that provides the disposition of one's personal property, and it takes effect when one person dies. We have a holographic will, and that's something done in longhand by the person that's getting ready to pass away, which is called the tester. Now, some states make no distinction between a holographic and other wills. In other states, variations of general law wills exist for holographic wills. And still other states' holographic wills will not be recognized, so it's important to check with the state that you're dealing with. Non-competitive wills, they're oral wills declared by the tester in the presence of witnesses. You could be at your bedside or in the nursing home or hospital, and that's one time you might use the non-competitive will. And usually such will can only be made during the tester's last illness. We also have soldier and sailor wills. Now, in almost all states, there are provisions made for members of the armed forces like me and Linda, who were previously in the military. They're allowed to make oral or written wills of personal property without complying with the formalities required of other wills. Now, these wills are in force even after the tester returns to civilian life. They must be revoked in the same manner as other wills. You have to go in and have them revoked. Now, there are different terms with wills. I've added this to my slide just in case you need a refresher on some of the terms. The one receiving a gift of real estate is called the beneficiary, but is also called a devisee in legal terms. The beneficiary of personal property is a legatee. Now, a devisee is a real property given by will, and a bequest or a legacy is a gift that is a gift by a will of personal property. Now, the person named in a will as the one to administer the estate is an executor or personal representative, and we'll be talking about an executor later on in the presentation. Now, one who dies without having made a will is said to die intestate, and we talked about that earlier. A person appointed by a court to settle the affairs of an end state, such as you or I that's getting ready to die, is an administrator, or an administratrix, or the personal representative. So you see the difference between the name of administrator, which is a man, and administratrix, which is a woman. So we're going to discuss some of the limitations of a non-competitive will. Now, a non-competitive will can do anything a written will that's fully executed according to the statutes of local jurisdiction, no matter how long ago the written will was executed. It can only be made during the tester's last illness. It only applies to personal property, and sometimes only a limited value of personal property may be disposed. Now, the witness frequently must reduce the will to writing within a specified number of days, and they must agree as to how the deceased will dispose of the property. So these are some of the key limitations of a non-competitive will. Now, the difference between distributing property per capita and per stirrups. Now, per capita, um, it's the lineal descendants of a descendant, including the children and the grandchildren. Now, if all the children were living at the time of the estate's death and the spouse was dead, the property would be distributed per capita, meaning per head or equally to all the children. If one child predeceased the estate and left two surviving grandchildren, then the property would be divided in equal parts on the basis of the number of children the estate had. And I have a little slide coming up that'll show this more graphically. Now, per stirrups is the dead child's part would then be divided into two equal parts, with one of these parts going to each of the grandchildren. This divides the property. If the deceased child left no children or other lineal descendants, then the surviving child of the estate would take the deceased child's share. So here's a little bit, a little graphic that's a little bit better in explaining per capita and per stirrup. So if you look on the left, per capita, you have Bob, who was the deceased. You have Alice, who already died. Then you have his siblings or children, Bart and Charles, and how that's split up per capita. Well, they each get 50%. Now, per stirrups, you have the same Bob and Alice and Charles. Okay, and now you see that because Alice has passed, then the grandchildren are getting 11%, and Bart 33 and Charles 33. So the primary duties of an administrator and how they differ from those of an executor. Now, the duties and responsibilities of administrators resemble those of executors with a couple of significant differences. First, in the appointment of an administrator, some states have a clear order of priority. The surviving spouse has first priority, followed by children, grandchildren, parents, and brothers or sisters. Second, an administrator must, in all cases, execute a bond guaranteeing the faithfulness performance of the duties. The primary duty of administrators is the same as that of executors, to preserve the estate and distribute it to the rightful parties. Administrators must act in good faith, with prudence, and within powers conferred on them by law. Now, if any part of the estate is a going business, with only a few exceptions, the business must be liquidated. However, the administrator may obtain leave of court to continue the business for either a limited time or indefinite time, depending largely on the wishes of those entitled to receive the estate. Third, parties dealing with administrators as well as executors must know the limitations of their authority. And now we're going to talk about, that's pretty much the conclusion of wills. And now we're going to talk about contracts.
I got all I need when I got you and I look around me and see a sweet light. I'm stuck in the dark, but you're my flashlight. You're getting me through the night. Hello from the other side. $600
So as you can see, Dr. Marino, that was just a short presentation on contracts and negotiation. So there are 5 requirements for a valid contract, and I'm going to compare them to the funeral contract. First off, it must be based on a mutual agreement by the party to do or not to do a specific thing. It must be made by parties who are competent to enter into a contract that will be enforceable against both parties. The promise or obligation of each party must be supported by some kind of consideration, such as a payment, money, delivery of goods, a promise to do or refrain from doing something that's a lawful future act, and given by each party to the contract. It must be for a lawful purpose, and in some cases, the contract must meet certain formal requirements, such as being in writing or under a seal, like if you were going to go buy a house. Now, there are different types of contracts, and I'm going to talk about how they differ from agreements during the funeral arrangement conference. So, void is no legal effect, not enforceable in court. Voidable, and a void is missing one element. Voidable, it's an enforceable agreement, but because of circumstances, one or both parties may elect to void, and it has all the elements of a contract. Unenforceable means the contract is not a particular form, such as a deed, must be in writing so it cannot be enforced. Now, express is very detailed, specific, either orally or written, and you saw kind of that at the beginning with Danny and those children. Implied is based on behavior, acts, or conduct. Parties indicate that they have a mutual agreement. And formal, it must be a special form or created in a certain way, seal, recognizable, negotiable instrument. Now, a simple is informal. Some could be in writing in order to be enforceable, like an airport ticket. A parking ticket that you get at the airport is based on behavior. You can either elect to park there or not, based on whether or not they're going to be responsible for your vehicle while you park. If they're not, then you might choose not to park there. Unilateral, offer or no acceptance yet. It's when the act is done in consideration for a promise, like Linda promises to pay $5 to me for taking out the trash. Bilateral, it's a mutual change of a promise for a future act. Dan promises Linda he will take out the trash, and Linda agrees to pay him $5, and I accepted the offer. Now, executory, it's in progress under development, but not fully carried out. Dan promises to take out the trash every day for 1 month for $10, but it's only the middle of the month, and I still have 15 days to go. Now, executed, it's a contract that has been completed. Dan has taken out the trash the whole month, and now Linda pays him $10. A quasi-contract is almost a contract, human property. It's rights over individual based on blood or marriage. Now, a contract must be an agreement, but not an agreement doesn't need to be a contract. An agreement means 2 people agree on a subject. So if I'm working at the funeral home during the arrangement conference, I might provide reception area for snacks and drinks during the visitation. I might tell the family that it's an agreement that we have, not necessarily something that we put in writing or in a contract. Now, a contract means 2 people are obligated by the terms of the agreement. The funeral home provide Linda the chapel for 6 hours for the visitation. That's in the contract that they get the chapel for that amount of time during their visitation day. Now, the difference between a contract and a quasi-contract. A contract is a real agreement between 2 or more parties. Now, under a contract, both parties give their consent freely. Now, under a contract, liability exists according to the terms mentioned and agreed upon by both parties. General contracts are entered into by interested parties voluntarily and without any compulsion. Now, a quasi-contract is not an agreement, but resembles an agreement or a contract. Quasi-contract, there's no consent of either parties as it's not voluntarily made. And quasi-contract, the liability comes into existence through the conduct of the parties and is based on morality, natural justice, equity, and good conscience. Quasi-contracts are also imposed by law. And these are the references I used, Dr. Marino, for my presentation. I use Ashcroft and Patterson. And subject to your questions, this concludes my presentation.